Welcome to the video edition of Real World Employment Law. I'm Declan Leonard. I'm the managing partner here at Berenzweig Leonard, and I also head up the employment law practice of the firm. And today we're going to do the inaugural video edition of Real World Employment Law. We used to do these Q&As that we would send out. We used to do them in writing quite often, where we would focus on real cases dealing with employment law, dealing with issues in employment law, and things of that nature. Todd, I know you were a loyal reader of that.
Loyal consumer, and I wanted to know why you stopped doing these. And by the way, my name is Todd Castleberry. I am president of the BL Media Group, Berenzweig Leonard. We're here in our lovely podcast studio in one of our early video productions. A little bit about BL Media, if I can get a plug in, Declan.
Absolutely.
Thank you very
Always
much.
going to do that.
So the BL Media Group, we represent John Riggins, Joe Jacoby, Dexter Manley, legendary Washington Redskins, guys that won Super Bowls. Let's just go with that. We handle so many different things for them, for all their business affairs, their podcasting, social media, business endeavors, and we are the executive producers of the McLaughlin Group, the long-standing political talk show by the legendary John McLaughlin, who passed away 3 years ago, and we just went national last week, so you can find it on your public television stations. We are the folks behind it, the BL Media Group. So why did you stop doing this column?
Yeah, I tell you why. I got lazy. No, I'm just kidding. You know what? You get work just sort of takes over sometimes on these things. But then when we put together this state-of-the-art podcast studio that you and I are sitting in, I thought, what a great opportunity for us to bring these into a new medium. Like, talk it through. You and I can kind of talk these cases through and sort of bring them to life, as opposed to putting them out there on paper.
I will be the average dope who does not know much, and if you can break it down for me that I understand, I think everybody's going to win.
No, that's great. And I just want to put in an additional plug for you. You used to be the producer of Riggo on the Range, John Riggins' old thing. I mean, you've really come down a few notches working with me here today. I don't know. I'm not sure what happened.
Sky's the limit. We shall see, Declan. So what's this first case that you want to talk about?
So today we're going to be talking about a case. It happened, the decision came out this summer. It was an employee who worked for the Postal Service in Washington, D.C. It sort of wound its way through the courts this past summer. And the main issue that we're going to be talking about today is this issue of retaliation in the employment context. So what the way retaliation works is, and this is when you're talking about discrimination and harassment, people being subject to sexual harassment in the workplace, racial discrimination and everything, you have those elements. But once they make a claim for discrimination, they are then protected under all these same laws for retaliation. They're not supposed to be fired. They're not supposed to be retaliated
All
against.
federal laws.
All federal laws. Some state laws also have these protections. But today we're going to be talking about federal laws. Yes. So let's talk about the case a little bit. So the employee worked for the Postal Service for a number of years, and the employee had an injury. It was a workplace injury. It was a ruptured right bicep. So, I'm sure painful, but nothing crazy, nothing that would be debilitating for a long period of time.
And they're supposed to be through rain, wind, sleet, and snow. The Postal Service gets it done.
That's
right?
exactly right. That's exactly right. When Amazon's not getting it done. And so he complained about this injury. He basically said, look, I need this time off and that time off. And there was a lot of back and forth over a number of months. But eventually he was terminated by the U.S. Postal Service. He sued, as many people do in this country, he sued for disability discrimination for, the arm injury, but he also sued for retaliation, basically saying, hey, I complained to you guys about this disability, and then I ultimately got fired for it. That's unlawful retaliation.
So he felt they held it against him. He felt that the injury was severe enough. He went through the proper chains and protocols to deal with the injury. They said, probably not so much. And then he felt they retaliated by firing him, basically complaining too much.
That's exactly right. That's exactly right. And the Postal Service said, well, wait a second. I mean, you're saying you're disabled. You've got this injury to your right bicep. We just don't think that rises to the level of a disability. So they filed a motion to dismiss the case, basically saying this is bogus, this is not true disability, and we want this case to be dismissed. And actually, the court agreed. The court agreed with respect to the disability aspect of the case.
Okay.
They said, you know what, there's just not enough there. There was some evidence presented that he was operating a snowblower. There was some evidence that he was loading furniture into a truck. And it gets a little bit more fact-intensive, but bottom line was it was hard to see how he was disabled. That should have been the end of the case, right?
Sure.
Yeah. Well, there's one problem. There was also a retaliation claim that was alleged in this one. And so then the court turned its attention to the retaliation claim and said, okay, do we get rid of this whole claim? Or do we get rid of this whole case? Or is there going to be something still standing at the end? The Postal Service said, look, if you're getting rid of the disability claim, why do we even have to bother with retaliation?
Sure.
I mean, don't you have to have some kind of, isn't this all premised on this injury to the right
If this didn't
bicep?
happen, how can you possibly even look at this?
That's right. So then it all came down to this retaliation claim. The court had to decide, do we dismiss that too? How do you think the court ruled?
I think they ruled in favor of the Postal Service.
You think because they dismissed the discrimination claim,
Right. There's
get
no
rid of
way
it
that
all.
you could claim retaliation.
And you would be wrong.
That's why I'm not a lawyer.
As so often happens. So here's what they said. They said, we are letting the retaliation claim go to trial before a D.C. jury.
Wow.
And obviously that is something that a company, or in this case the U.S. Postal Service, has to be very concerned about. And you would say, well, how does that even make sense? I call it the retaliation trap. I've been doing this over 20 years, and I have just become convinced that the retaliation trap for companies is really one of the most potent things. Because here's the thing. When an employee complains about harassment or discrimination, in order to be protected under the retaliation provisions of these federal laws, they don't necessarily have to be right about their underlying claim. Is this not a disability to the right bicep? Who knows? All that has to happen under federal law is that the employee has to have a good faith basis in their mind, a good faith basis, that what they were doing was engaging in what they call protected activity. In other words, I'm complaining about something that I think is unlawful, and so therefore I'm protected. And so because here the employee thought that they were covered by the Disabilities Act, and that they were complaining and trying to remedy a problem in the workplace related to their disability. When they ultimately were fired, the court said, we can't at this stage dismiss it. We need a D.C. jury to determine whether or not, it should be knocked out altogether.
That is fascinating. So the retaliation, he was fired. Was he fired after the lawsuit? Or did did he file a lawsuit because he was fired?
He filed the lawsuit because he was fired, saying, I was fired for two reasons. One, I got this disability, and then when I complained about it, the company really just didn't like, or in this case, the U.S. Postal Service, really just didn't like the fact that I was the squeaky wheel, that I was complaining, and therefore I was fired because I was basically a hassle in the workplace, and that this was retaliatory. Now, this doesn't mean that the employee is all of a sudden going to collect a big paycheck in this case. It just means really that the case is going to go in front of a D.C. jury. Once you get in front of a jury, in some ways, sometimes the U.S. Postal Service or any other company, I mean, that's kind of a loss anyways, because, then you're really, really rolling the dice. You really want to control these with a judge dismissing them at what's called summary judgment.
And certainly the big governmental agency, the United States Postal Service, going up against an individual letter carrier, doesn't play well in front of a jury. How do you see this ending up?
You know what? I think it'll be a tough one. I still think that ultimately the Postal Service will prevail because I think there were some other intervening acts that probably would have justified the termination. But it's a roll of the dice. I mean, you never know, and it's not a good way to run a business. It's not a good way to run an organization like the Postal Service, rolling the dice in front of a jury in D.C. So in my opinion, just by the fact that it gets there, the Postal Service loses. Just because even if they ultimately win, it becomes a Pyrrhic victory because it's resources, it's a lot of time, it's a lot of money just to mount a defense and bring something to a trial. Yeah.
The retaliation trap, I love it.
Yeah.
I even understand this, Declan. You've done outstanding.
Yeah. We tell our clients all the time. We tell our clients, listen, I mean, you're going to have to take action against employees from time to time. It's inevitable in the workplace. You have to train your managers not to then engage in retaliation. Retaliation can take all kinds of forms, not excluding somebody from going out to lunch with the rest of the group, things of that nature. All the way up to, suspension, demotion, or termination. Those are the more extreme and obvious ways to retaliate. But companies have to be so sensitive that, look, I know you might be in defensive posture when you get accused of something. you just need to not engage in anything that could be perceived as retaliation. Otherwise, it's going to come back to bite you.
Great information. Minor things can turn into big things, and especially as companies grow, and sometimes small and mid-sized businesses don't understand the importance of you gotta have some policies in place and take this stuff serious.
No, absolutely. So it's a really important one. We try to hit a very universal topic in our first inaugural video edition of the Real World Employment Law. We plan to do these, if I can bring it back, we plan to do these very regularly, hopefully more regularly than I was doing the written ones. And so stay tuned. We hope you find this very useful.